Good morning. My name is Surisha Ganta. I'm an attorney with the Pro Bono Partnership of Atlanta. Thank you for joining us in this installment of our monthly webcast series. We're excited today to have Marla Nicholson with Jenner here to speak to us about technology considerations for nonprofits. Before she starts talking to us about this topic, I would like to tell you a little bit more about Pro Bono Partnership of Atlanta. We are a 501c3 organization that seeks to connect nonprofit organizations in the metro Atlanta area with attorneys who are able to provide pro bono business legal services. If you're interested in becoming a client, you will have to be a 501c3 organization located in or serving metro Atlanta area, serving low-income and disadvantaged individuals, and otherwise unable to afford legal services. Please visit our website for more information or to fill out an application to become a client. You'll also find at our website a lot of great resources, including articles and webcasts. And today's webcast, will also be there in a couple of days. And just a little bit of a legal disclaimer. Today's information is just general advice. It is not specific legal guidance for your organization. If you have specific questions, please reach out to your PBPA attorney. And the webcast is copyright 2018 Pro Bono Partnership of Atlanta. And now, Marla, I'll hand over the mic to you.
Thank you, Sharisa. Good morning, everyone. First wanted to start off by thanking the Pro Bono Partnership of Atlanta for allowing me the opportunity to come to speak today about this topic. I'm really excited to be here. I wanted to just go over the agenda briefly before we get started. My plan was to give a bit of an introduction to me, so you know exactly why I'm here talking to you about this today. In short, I've got a pretty good amount of experience on the topic. Secondarily, wanted to talk about just the purpose or goal for today's presentation, what I'm hoping that everyone will get out of it. And then we will get into the meat of the conversation and talk about the top 10 considerations that nonprofits should consider when interfacing and doing business with technology providers. And then we'll take some questions. On questions, I do want this to be interactive, so certainly if there are questions throughout the presentation, please don't hesitate to ask, and we will field them and get those answered in short order. So on for the introduction. You'll see a number of trademarks there. I have had the pleasure of, I went to school at Penn State in Pennsylvania, studied in accounting. Directly after that, went to law school in Ithaca, New York at Cornell. After graduation, I spent about 3 or so years at Jones Day here in Atlanta. I was in the corporate department doing primarily mergers and acquisitions and securities work, but that was my first foray of really delving into a lot of technology agreements and getting very acquainted with those. After my stint at Jones Day, I went to a software company in Atlanta in the perimeter area called CDC Software, where I handled the bulk of their vendor agreements, among many other things. And before my current position, I spent about 5 years at LexisNexis Risk Solutions, supporting their insurance business, doing a lot of contract work as well as data privacy work. And now I am at Jenner. It is a soda ash producing company, one of the largest in the world. We've got a really cool mine out in Wyoming. I actually got a chance to spend some time there last week, which was really exciting. And for them, I do all of their vendor agreements, including technology agreements. So on to the purpose for today. Really the goal is to provide the audience with a general familiarity with important terms that they should be aware of. I'm aware that many of you are probably not using attorneys when you are negotiating agreements, and so it's really important for you to have a fundamental understanding of really what you are agreeing to, and to the extent that you don't agree with it, to be able to issue spot and know when to really engage counsel so that you can get the help that you need so that you're getting a deal that you actually can agree to and are comfortable with. So on to the top 10. So the first one is really a catch-all, and it really it consists of those subjective considerations that need to be thought of. And I felt like I'd be remiss if I weren't to talk about some of the non-contractual items that you need to really consider, because to be quite frank, the contract is not going to be the panacea for all your ills with a vendor or any third party. You can have a rock-solid agreement, but the last thing you want to do is be litigating it. You really don't want to be dealing with unscrupulous vendors, and so reputation is one of those things. Past behavior is indicative of future behavior, and so going online and getting word of mouth referrals from others who maybe had the services that you're looking to get. And also taking advantage of those sites like Yelp and other things to try to get some intel in terms of how the company that you're contemplating doing business with has handled other relationships. And then also, how long has this company been in business? Really, you're wanting to get telltale signs that this company can do what you're wanting it to do, what you need it to do for your company. Also, it's really important to make sure that they're fiscally sound, right? You may have a great contract and a clear breach of contract and get a judgment against this company, but if they don't have any assets or financial wherewithal to pay the judgment, then it's not worth the paper that it's written on. So I really can't underscore the importance of those subjective considerations and just making sure you're doing business with a reputable company. So now on to number two. Number two is contract scope. Now we're going to be getting into some of the items of an agreement. And one of the things I didn't mention is you're getting a lot of bang for your buck today, because a lot of these things are really important for technology provider engagements, but then also for other agreements as well. So a lot of this will be applicable and helpful to know as you negotiate all types of agreements, but certainly the technology provider ones. So for the scope, the big thing is, this is one of the biggest aspects that is really important for you to have detailed sort of in specificity on in your agreement. This really does itemize and create the parameters of what you are engaging this provider to do. And so you want to make sure that it's crystal clear and both parties are in agreement in terms of what you'll be receiving and what they'll be providing. Not only initially, but this is one thing you definitely would want to keep in mind, is just anticipating that there may be changes or additions to your scope. And really having a good process in place to make sure that, to the extent that your provider is engaged and throughout that engagement there is a change in scope, that you are following what is required in the agreement so that it's appropriately captured and that everyone continues to be on the same page throughout the engagement. I've seen this on a number of occasions, unfortunately, where, for example, the agreement might say that the scope can change by agreement of the parties. It has to be in writing, though, and then the business person and the technology provider will be talking amongst themselves and agreeing to without others in the organization aware of such agreement that the scope is going to change, and then there's this disconnect when it's time to pay, for example, or there's a disagreement even between the two parties that were talking that weren't involving their respective organizations in terms of what that change was. And so it's really important. Typically what you want to do is to, and there certainly are exceptions to this, but you want to make sure that you are properly, memorializing the changes in scope throughout the engagement and making sure that they are, for example, made amendments to the agreement or modifications to the agreement, and make sure that it's in writing and signed.
I have a question. Should those scope changes, those be written out by the technology company or the client, or does it matter?
I think, and that's a good question. So the question is should the changes be, should they be written out by the technology provider or the organization that's receiving the services, or does it matter? I would say what really matters is ensuring that it's in writing for one. It's signed by both parties, so it's very clear that both parties agree to it and that they actually agree to it, right? So not just signing and not really understanding what the implications are of that modification, truly understanding it and agreeing to it and making sure that it's, a third party who were to see it would be able to, without a doubt, understand that, yes, both parties agreed that this is going to be a change in scope. So on to number 3, which is price. At first blush, it seems like, this is not a big deal, right? But there are a lot of nuances to price that I would recommend you consider before engaging and really finalizing an agreement with a technology provider. And a lot of these concepts, you'll notice, there's interplay between them. So, if you'll recall, one of the subjective considerations was, how reputable the company is, how fiscally sound the company is. There's interplay between those considerations and price. So, for example, you can have it's situated so that you pay upfront for the services, or it could be phased, or you can pay after the whole job is completed. Now, obviously, a part of that's going to be dictated by what's typical, right? If this is a really big technology provider and they've got a monopoly on the market and they do things one way, you might not have much latitude to deviate from what they typically expect and how they conduct business. But let's say it's a relatively newer company that doesn't have much of a stronghold on the market, and you don't know how fiscally sound they are, you may be a little bit more reticent to paying everything up front. You may want to have it phased or pay once you've received all the services and you've signed off and you've confirmed that it comports with the agreement and your understanding of what you would be receiving. Also on price would be this concept of, how do you price a job, right? So is it going to be a fixed price where it's just a lump sum, X dollars, or is it going to be hourly? And sometimes hourly is you would go that route if the parties are unclear in terms of how long it's going to take for the engagement to be completed or the job to be finished. You also could consider doing a hybrid, so maybe having a fixed fee up until a certain point, and then anything beyond that, a certain amount of hours, for example, would be charged an hourly rate. One of the things I would caution everyone about, I've seen this quite frequently, is I've seen where there'd be a provision in an agreement that would say that the prices are going to be at the established rate of the vendor. That pretty much subjects you to whatever price that the vendor wants to charge. And the whole idea of a contract is to make sure that you've got definitiveness in terms of what you're agreeing to, and there's foreseeability, and you know what the deal is. And so when you have provisions like that allow the vendor to basically insert their fees at whatever rates they are without your actual agreement, it undermines the whole concept of actually having an agreement. So I'd strongly encourage you to think twice about accepting those sorts of terms and really getting greater definitiveness in terms of what it is you will be paying for the job that they would be completing for you. The other thing on price, I'd say, would be to watch out for hidden fees. So a lot of times you'll see, and this is particularly true if you're dealing with a vendor who is in another state and they've got to come on site to your establishment to do some work. It's not uncommon for them to receive money for travel expenses, for example, that they may incur due to their travel to come on site to your facility. I would caution against having just blanket entitlements on the part of the vendor to receive or be reimbursed for travel expenses. It's better to kind of lock down those fees and that ability on their part to be reimbursed by allowing, for example, your organization to sign off in advance for any fees that are above a certain dollar amount, and that would be on a per expense basis. But then also wanting to cap it or saying if it becomes if you've accumulated more than a certain amount of fees in totality, then too your organization has to sign off on it, because what you don't want to have done is them being able to kind of incur fees right below that first threshold, and a number of them, and then in aggregate it ends up being a lot that you're on the hook for that you have not really had an opportunity to try to defray or to get in front of. So that's pretty much on price, unless there are any questions. We'll move on to number 4, and this is click wrap agreements. This is really a term of art. Really what I mean by click wrap agreements, and I talked about it just a little bit before when I had mentioned the bit on price, and how I've seen pretty frequently vendors wanting to slip in this ability for them to have price be dictated by their established rates. That's really what I'm getting at with this click wrap agreements. It's this idea of allowing the terms and provisions of a vendor to be inserted automatically into the agreement between you and the vendor without your ability to actually review and agree to those specific terms. Again, it undermines the whole concept of having a contract to begin with. I have an example on the slide. You'll see it reads, "This service order shall be governed by the terms and conditions of the MSA set forth at vendorswebsite.com." I can't tell you how many times I've seen a provision very similar to this, and even outside of outside of technology agreements. It's really a common thing, and I would strongly encourage you to consider whether or not you're comfortable with those types of provisions. What I've done is, and this oftentimes works, although there does seem to be some pushback from time to time, is to actually ask the vendor to take those terms and conditions off the website. So get a static copy of the terms, review them to the extent that you agree with all the terms, right? If you don't, then certainly those need to be modified to so that both parties are comfortable. But to the extent that you're comfortable with those terms, then have that be an appendix or an exhibit to the agreement that you're signing, and then so that way the vendor gets the terms that they are comfortable with, you do as well, and then there's not this ability for them to modify their website, and then it automatically affects the bargain that you have negotiated with the vendor. So that seems to be a happy medium that most folks are comfortable with, and I'd suggest you to give it a try. Number 5 is service level agreements, and this is, they're called SLAs for short, and it doesn't necessarily mean that this is a distinct separate agreement from the services agreement that you're going to have with the provider. Oftentimes it is a separate agreement, but the terms can certainly be embedded in the main agreement to just have it in one place. There are a lot of different facets for services agreements, but the idea is just to have a common understanding in terms of what level of service you're going to be entitled to by way of performance standards, have that there. And just to give you a bit of an example, let's say you have your organization is basically you're providing services to the indigent community in Atlanta to give a space for people to come and use the internet and to apply for jobs. Let's say that's it. And so it's really important for you to have internet that's functioning during a certain time of the day. then you may want to consider to have a service level agreement with your internet provider, although they typically are big ones, and are difficult to really modify their normal sort of SLAs. But let's say you have the ability to do that with the Comcast of the world, and you want to have it so that they're required to keep the internet up and running, 99% of the time from Monday through Friday, from 9 a.m. to 5 p.m. That would be basically the objective, the performance standards. In there, you would also want to have, information on, well, what are the remedies or ramifications if they do not perform? Let's say they shut down or they do some maintenance work in the middle of the day for 2 weeks straight. Well, it would be good to have in that SLA what exactly happens if they were to do that, because that obviously impairs your ability to offer the services to the community that you're there to provide. And then also, it provides a means to clearly know how to escalate problems within the respective organizations to the extent that the SLAs are not being followed, or they're not, they're not being complied with.
Can you speak a little more about escalation? Like, what does that mean, and when that might be triggered?
Absolutely. So the question is, can I speak a little bit more about escalation, and when is that needed, and when is it triggered? So when I talk about escalation, I'm really talking about if you have a problem. So let's say, going back to the example, the Comcast is down for 2 weeks straight. The escalation provisions in the SLA would really talk about, well, what does your organization do then? It could be very specific and say that you would then, if there is downtime that breaches the performance standards that are stated in the SLA, then your organization has to reach out to XYZ person, right, at Comcast to notify them of the problem, for one. And then it would also maybe address that person at Comcast has a certain amount of time to respond back to you, acknowledge the problem, let you know who's working on it and how long it will be, maybe why it's occurred, but how long it'll be before the problem is remedied. That's an example of a sort of escalation process, and it gets heightened, right? So that might be, if it's been down, the internet's been down for a day or so, but certainly after, if you run into really egregious scenarios, and this is something that, particularly if you're looking to engage a provider for something that's really instrumental to you doing business, you're going to want to think about those scenarios where the really egregious breaches of the performance standards, and what happens then. You may want to not just have an ability to terminate, but really to get some compensation for the more egregious breaches. And we'll talk a little bit more about termination and such later on. But okay. Number 6 on our list is, this is a really meaty one. It's confidentiality, ownership, and intellectual property. So before I was saying that a lot of these items are applicable generally speaking, this is the bucket that is really important for those technology provider agreements, because a lot of IP is typically implicated in these sorts of arrangements. So just, I'm not going to be able to do this topic too much justice in the short time that we have together, but I'll touch on them briefly, and certainly if anyone has questions, feel free to ask. So confidentiality, so obviously this is this idea that there's information that's exchanged between the parties. Really, if it's sensitive in nature, one would think that both organizations have a vested interest in ensuring that information remains secret and is only really used to facilitate the transaction. So one thing I would encourage you to kind of think about as you're working with providers, and particularly in the earlier phases of those relationships, is to try to figure out or anticipate, are you going to get an agreement in place pretty soon? And also, are you going to get an agreement in place prior to you exchanging your confidential information? If you're not, if you think that there's going to be some significant legwork that needs to be undertaken prior to you getting a services agreement in place, then I would encourage you to consider getting what's called an NDA, non-disclosure agreement in place, so that you're at least protecting your confidential information as you work through the nuts and bolts of the agreement and get something more definitive, longer term with the company. The other thing here is ownership. So it really is kind of thinking about the relationship and all the things that you'll be providing to the technology provider, all that it will be providing to you, and really trying to figure out who do you think should own that information. So certainly it's not atypical for the information that you provide to the provider would be something that you would probably expect to continue to own. But I think it gets a little bit more dicey when you're talking about the information and that provider will be providing to you during the course of the relationship. There may be a disconnect in terms of what its thoughts are in terms of ownership and yours are with respect to that information and other intellectual property that you'll be receiving. And so it's good to just kind of think about all the possibilities, and then who do you think should own it, and really having those conversations with the provider to make sure that you're in accord and that the agreement actually is very clear about those ownership aspects. And to the extent that you don't end up owning the information, then certainly you'll want to consider whether or not you at the very least would need to have a license to use that information for a finite period of time or indefinitely. But I would say that unless you are incredibly comfortable with those sorts of issues, I'd strongly encourage you to engage counsel because it can be a bit tricky to navigate without it. Next item here is indemnification. And indemnification is a fancy word, but essentially it is, during the course of a relationship, there are going to be, unfortunately, the possibility of losses and liabilities, and really just trying to think about what could happen bad, right, over the course of a relationship, and who should be responsible for that. For those losses, and so indemnification is a way to take a loss that may otherwise have been your responsibility and shifting that loss and making it the responsibility of the other contracting party. So you'll see here I have two sort of buckets of indemnification. One is more like an insurance-like indemnity, and it really is, it's like event-based, if you will. So something happens bad, and then there may be losses or damages that may arise from that unfortunate event, and indemnification will basically take a loss that might otherwise be yours that was associated with that event and make it the responsibility of the other party. So in technology agreements, you'll see, a lot of times there's this possibility that there could be some IP infringement, right? And it's typical that the party that is providing that intellectual property to be responsible for any third-party claims that may arise due to the use of that IP. So typically they have representations and warranties in the agreement that say that they do have proper ownership and they have the ability to provide you with the services using the IP that they're providing you with. And to the extent that that's not the case, that they should be responsible for that. Yes? Okay, and so the other item on here I would say would be indemnity zone breach. This is another very common indemnity. Parties who breach agreements, typically, if there are any losses that arise due to those breaches, they typically are on the hook for that. I've seen exceptions to it, but by and large, that's pretty common. All right, we're going to speed up just a little bit because I know I'm running out of time here, but we are towards the end, so that's good. Number 8 on our list is limitations of liability. So the big thing here is really just this idea is, without a clause like this limiting your liability, skies is the limit, right? Think, on your part, you're receiving these services, but you could be exposed to an unlimited amount of liability due to the arrangement. It's not really as much of a sensitive topic with the receiver of services, to be quite frank. This is going to be something that probably the service provider is going to be wanting to get inserted in your agreement. And it's not uncommon for them to want to cap their liability to be commensurate with the cost of services. So you'll see it's typically capped in two ways. One is the type, right? And the other is amount. I just spoke about amount. Typically, it's the cost of services. You see that, or 2 times the cost of services. Other is type, and you'll see in the example that I have here where there's just an itemization of all these different types of damages or liabilities that are just off the table. I wouldn't. This is something that's very common to see. I would encourage you to talk to counsel if you have a situation where you're dealing with a provider that's providing something that is just really important to your organization, because although this is a typical provision, there's no one-size-fits-all with these, and sometimes it's not reasonable to agree to, for example, exclude consequential or special damages. So this is one of those things where if it's something really important, I would encourage you to reach out to someone who specializes in the area. Number 9 on our list is termination. This is it's something that is typically an afterthought in agreements. It's towards the end of the agreement. People are pretty tired and want to just get things signed up. But I think, I really encourage you to spend some time with this, particularly if you have an engagement where the services are really important to your organization. You're going to want to make sure that, you are afforded with enough heads up if the provider wants to pull out and no longer provide the services. That will allow you to figure out another sort of alternative to getting the services that you need from another vendor. And also, what's tied to this is, any penalties that may be associated with termination, making sure that those are spelled out in the agreement. And also prerequisites. You want your vendor to be able to terminate without cause, upon written notice. That's going to put you in a pretty precarious situation, particularly if these are really important services for you. So you may want to think twice about allowing them that ability. If it's a really important services, you may want a longer time, so a longer heads up or notice period. And you may want to consider, requiring that there actually be a material breach and your organization having had the opportunity to cure within a certain amount of time prior to them being able to terminate. Number 10 on our list is transition periods post-termination. So this is kind of, dovetails nicely into the previous item. Further to the point of you having a really important service that you need. If you're unable to get the more favorable provision, which requires them to have actually, given you a very long notice period, and you had materially breached the contract and not cured the breach within a certain period of time. Under those circumstances, if you're not able to get that, you may want to consider at least being able to continue on with the benefit of the bargain for a period of time after termination so that you're able to situate your organization with another provider after termination. So that's number 10. So I think we're now on takeaways. I'm hopeful that during our chat you were able to really understand that the contract can't cure all vendor woes. You can have a great contract, but if you do not have a scrupulous vendor who is who's really poised to provide the services, then you're probably going to have an uphill battle with that vendor. The second on here is, just making sure that you read and thoroughly understand the agreement before you sign the agreement, and to the extent that you do not, that you engage competent counsel. And that's all I have for today.
Do you have any tips if you want to support a small startup startup technology vendor, but you're not sure about how long they're going to be around, like through the end of the contract? Do you have any tips on what to take into consideration?
So a small startup technology, so this is the vendor actually, yeah. And you're not sure how long they'll be in existence?
Exactly, but they have a product, a new innovative product that you want.
Okay, interesting. Yeah, on that, I mean, I would say, I mean, it really does vary. A lot of it's going to depend on how important the services are to your organization as well. But I would say for that sort of engagement, you're really going to want to kind of have the ability to have a good trial with them, trial run. You're not going to want to have long terms that don't allow you to terminate, unless they breach the agreement, materially breach, and they've had a very long period to cure and that sort of thing. I would say you might want to have just a period to kind of test the waters and see if it's something that's mutually beneficial for both organizations to continue to pursue.
Okay, great. That's all the questions we have.
Okay.
Thank you
so much.